we will introduce various actors or subjects of international law, their process, rights, power, and obligation. It contains the state as the main legal actor and other actors such as international organization, non-governmental organization, multinational corporation, and individuals. Subject of international law is an entity possessing international rights and obligations and having the capacity to maintain its right by bringing international claims and to be responsible for its breaches of obligation by being subjected to such claims. Subject of international law is legal subjectively or personality is relative and not all participants in international legal system hold the same rights and obligations. While in Reparation Case 1949, legal subjects are not necessarily identical in their nature or in the extent of their rights, and their nature depends upon the needs of community. International Court of Justice in the 1949 case reparation for injuries suffered in the service of the United Nations provided competence to bring an international claim is the capacity to resort to the customary methods recognized by international law for the establishment, the preservation, and the settlements of claims. The first capacity of international legal person is to bring claims in respect of breaches of international law. For example, Iran hosted crisis with militants in Iran seized 66 American citizens at the United States Embassy in Tehran and held 52 of them hostage for more than a year. The second capacity is to conclude treaties as shown in Article 7 Part 2 in Vienna Convention on the Law of Treaties. The third capacity is to enjoy immunities and privileges from other state and national jurisdiction. The last capacity is subject to some obligation of international law. For example, Pacta sunt servantes means that every treaty is binding upon the parties and they must be executed in good faith with means to carry out obligation without malice.
According to Article 1 of the Montevideo Convention, the state as a person of international law should possess the following qualifications. For the first one is a permanent population. This refers to a population that is linked to a specific piece of territory on a permanent basis. The population must be reasonably stable. Nomadic tribe qualify as a state as they had lived in the specific territory in Western Sahara. For government, the convention does not demand that the government should be democratic or legitimate. For example, civil war may provide a serious challenge to effective government, but the state still exists in international law like Syria and Libya. Defined territory refers to which control of the state is exercised and which demarcates the state from its neighbor. For example, India and Pakistan still exist as a state. For legal capacity to exist, there must be a degree of independence from any other state. For instance, Hong Kong and New South Wales, their local government do not have the capacity to enter relation with other states. List of state fundamental rights. Regarding to the development of right and legal instrument dealing with fundamental right and duty of state, the convention is one of the first example right and duties of the state. Recognition of statehood can be defined as the formal acknowledgement or acceptance of a new state as an international personality by the existing state. Theory of recognition. For the declaratory theory, an entity is a state once the conditions of statehood are met regardless of the attitude of other states toward the new entity. And for constitutive theory, only when other states decide that the convention conditions are met and consequently acknowledge the legal capacity of the new state. De facto recognition is granted when a new state holds sufficient territory and control of a particular territory, but the other existing state considers that it does not have enough ability, like Soviet Union and UK case. For the jure recognition can be granted if with or without granted de facto recognition.
Hi, I'll be explaining about the international organization as a subject of international law. So to start, what is international organization? International organizations are established by states, and it is the founding states of each organization that determine their powers and functions. International organizations are distinct and independent from states. It is an international entity and it is capable to possess international rights and duties under the international law. Examples of international organizations are United Nations, UNESCO, ASEAN, World Health Organization, and the European Union. The legal personality of international organizations are determined by the capability of the organizations to make treaties. Treaties are essential to set agreement among states and international organizations. Number 2, international organizations should also have the ability to bring states under claim regarding any issues or disputes in the international level. 3. International organizations have standings in international tribunals to settle any kind of disputes and issues. Number 4. International organizations also enjoy immunity from certain obligations and penalty. Some organizations are set up for a variety of purposes such as the United Nations, whereas others are set up for a very specific purpose, as in the case with the International Labour Organization. This study is regarding the reparations for injuries suffered in the service of the United Nations in 1949. Bernadette was a Swedish diplomat who was sent as a UN mediator to Palestine during the conflict between Arab and Israel. He was then shot on 19 September 1948 by a group of Jewish people. Regarding his case, UN wrote a petition to ICJ. The outcome of the case was UN managed to bring international claims, as it had the rights under the obligations of UN due to the damage caused towards UN and for Bernadette.
This part I want to explain about individuals in international law. Before the 20th century, the view was that the individual was merely an object and not an international law subject. Overall, international law does not consider individuals other than in the abstract sense for centuries. They are not considered competent to have rights and obligations under international law. However, since World War I, the nation has become increasingly aware of the need to protect the rights of individuals under international law. There is no general rule that individuals cannot be subject to international law, and in certain contexts, individuals have rights inuit personae that they can justify international action. There are norms that set the direct responsibility of the individuals. Individuals who commit certain crimes under international law should be punished according to international law. For example, piracy, counterfeit trade, genocide, war crimes, and crimes against humanity. Individuals have a level of international personality, but to a very limited extent, far more limited than the legitimate personality of an international organization. The number of international law rules exists for the benefit of the individual, but that is not necessarily the rule of creating rights. One way to prove that individual rights exist under international law is to show that the agreement granting such rights gives individuals access to international court or tribunal to uphold their rights. The individuals do not have local standing or access to international court and tribunal. Most of international tribunals are not open for individuals. Article 34(1) of ICJ statute only states may be parties in cases before the court. Individual or corporation has no local standing before the court. Individuals may be entitled to appear in international courts. For example, the European Convention on Human Rights and Fundamental Freedom. Any private individual who are nationals of state parties can bring an action before the European Court of Human Rights against their own government for violating human rights.
First, NGOs have governing influence on the processes that lead to the creation of international law. Second, they enhance enforcement of international law by providing vital information to monitoring bodies. And the third, NGOs do not possess the rights or obligations under international law and legal personality, except ICRC, where its mandate is grounded in international conventions. NGOs don't have voting rights, but they can still exercise a substantial influence on the discussion within a given organization. For example, NGOs participated extensively in the drafting of the Rome Statutes of the International Criminal Court and UN Declaration on the Rights of Indigenous People.